Test Prep YouTube channel. I am Ashish Bhargav. Today I welcome to in the session of deep dive, which we usually held on Tuesday and Thursday. And what we discuss in the deep dive session, we discuss about a particular one topic. We go to the in the very depth, and we discussed about each and everything in the whatever the mentioned topic, as and we can say in the bird's eye view. So in deep dive, the today's topic is collegium system. As we know that collegium system, that is very important, and this system is responsible for appointment and transfer of appointment and transfer of Supreme Court and High Court judges. So again, I welcome to each and everyone. Please, I humble request to everyone, if the students is watching the YouTube session, please share to each and everyone so that the maximum number of students can get advantage. So a little progress each day adds up to a big result. Try to focus all these things that we have discussed in the YouTube session, and then try to improve your skills. And here is an article taken from the Indian Express. Debate over the collegium system, how are SCs and HC judges appointed. So with the perspective of this article, is the main ambition is to reach to the only for the law aspirants, but apart from the law students, any students who is preparing for other examination can also watch it. But with the perspective of CLAT and AILET exam, this is very important, because the aspirants who is preparing for this exam, as we have only the 1 month is remaining, because October is going on, November is left, because December 12th is a date fixed for the CLAT exam. So that we need to keep an eye on that, the constitutional provision, what is the Supreme Court and High Court judges are appointed, and what is the role of collegium system. Because as we know that collegium system allows judges to appoint and transfer themselves. It has been debated for a long and sometimes blamed for tussles between the judiciary and executive and the slow piece of judicial appointment. So as we know that we have three forms of structure. If we talk about three forms of structure, one is legislature, and then executive, and then judiciary. Why we have independent judiciary? Because that no executive and legislature can enforce any laws to implement on judicial system. So this is what we discussed in this today's article. So this is very important session. Please share to each and everyone and subscribe our YouTube channel. Initially, we have to understand the nitty-gritty of the subject. And what is the nitty-gritty of the subject is general structure of Indian judicial system. So judiciary, as we know that the government of India is working. Government of India is working on the three segmentation. The layers of the government is here is, we can say, legislature, and then executive, and then judiciary. While we talk about in our country, legislature is, that means that one who is making laws. So here is the parliament, and as we know that parliament consists of Lok Sabha, which is the lower body, lower house we can say, and then Rajya Sabha, which is known to be upper house, and then we can say president. So parliament consists of Lok Sabha, Rajya Sabha, and president. And what is the executive? Executive, we can say that there's two terms you need to understand. The executive, we can say that the executive, which means that if we talk about executive head of our country, then the answer would be president. And if you talk about the executive head of the government of India, the answer would be prime minister. Who prime minister is also head as council of ministers. Executive, we can say that in short, he is a prime minister. So in our country, prime minister is doing each and everything with the name in the name of president. So this is what you need to keep an eye, like what is legislature is, what is executive is in our country is the PM, and judiciary, as we know, that Supreme Court and High Court. So we have, as we know that we have a parliamentary form of government. So in our country that we have parliamentary form of government. So what does it mean, the parliamentary form of government? So in short, that we can say parliamentary form of government, which means that legislature is solely responsible to executive. So it means that you need to understand the legislature is responsible to executive, or executive responsible legislature. No. So this is the opposite one. So in our parliamentary form of government, we can say that here is executive. Executive is solely responsible to legislature, which means that Prime Minister, PM is responsible to legislature, which means only the Lok Sabha, not responsible to Rajya Sabha as well. So we need to understand that how general structure of Indian judicial system is working. Here the top notch is Supreme Court, which is known to be as an apex court of our country. Apex court of our country. Supreme Court is in the top notch. Then if we go to the hierarchy, here is the High Court, and we now talk about here district, and here is the metropolitan areas. So district, as we know in district and session court, as we know that like Saket district court in Delhi and different places, and civil subordinate judges court, provincial small court, and criminal court of session. And in metropolitan areas, like we talk about Delhi, like we talk about Mumbai, while we talk about Bangalore, and we talk about Chennai. So in metropolitan areas, that metropolitan magistrate court, city civil and session court, and presidency small court. While we talk about civil court is Munsif court and Nyay Panchayat, which is Gram Nyala, we can say that. And criminal court of session having two court, we can say in Chief Magistrate Court and Panchayat Adalat. And as you know that in our country there is a term is a Lok Adalat, which is appointed by the Nalsa. We will discuss later on in this YouTube session. So stay tuned. So Panchayat Adalat and Chief Magistrate's Court is having two types in Judicial Magistrate and Executive Magistrate. So Panchayat Court are functioning in civil and criminal areas under various regional names like Gram Nyalai, Nyay Panchayat, Panchayat Adalat, Gram Kachehri, etc. So basically we need to understand that how our judicial system is working, because until and unless we will not exactly understand how judicial system is work, we will not able to understand how is our collegium system is. So initially we have to understand the nitty-gritty of the subject, then we further move to the another things. So Panchayat Court, as we know that having different names in different places, as we know Nyay Panchayat, Panchayat Adalat and Gram Kachehri. As you know, there is a term is Lok Adalat and a fast track court. So in short, we need to understand Supreme Court and then High Court and district and metropolitan areas. While we go to the further moving, what exactly is general structure of the judicial system and which article is this covered for? So Indian Constitution has established an integral judicial system with Supreme Court at the top, followed by High Court and subordinate court. The unified judicial system enforces both central law as well as state law. As we know that there is a law-making process in our country, first goes to the Lok Sabha, then we go to the Rajya Sabha. Depends on that what exactly the Constitution wants to amend, and then we can say that there is a simple majority, there is a special majority, and then we can say that whatever the majority is defined as per the constitutional law, then the bill passed, and once the bill when the President of India sign on it, then bill is known to be as without President assent, bill cannot be converted as an act. This is what exactly law making in our country. So unified judicial system enforce both central law as well as state law. This integrated judicial system of India has been adopted from the Government of India Act 1935. So keep in mind how the judicial system was enacted in our country. The only act is Government of India Act 1935. Article 124 to 147 of the Indian Constitution deal with organizations, independence, jurisdiction, powers, procedures of the Supreme Court. So which article define of the Supreme Court, establishment of Supreme Court's answer would be Article 124 to 147. Parliament, has the power to make law regulating constitution, organization, jurisdiction, power of the Supreme Court. So in short that we can say that Parliament have a solely power to make laws in our country, and as we know at the time of farm laws, the law making, because Parliament have a law making body. In our country we have a quasi-federal structure. Quasi-federal structure matlab kya ho gaya? Matlab this means that this is totally defining its quasi-federal structure, which means that in short we need to understand quasi-federal, which means what? Which means that maximum power is tilting towards the center. That is known to be a quasi-federal structure. So Parliament has the power to make laws regulating constitution, organization, judicial power of the Supreme Court. Here we need to understand what is the role of Supreme Court, High Court, District Court and subordinate courts. Supreme Court of India, its decisions are binding on all courts, can transfer judges on the High Court, can move cases from any court of itself, can transfer cases from one High Court to another. This is the power of Supreme Court. In short, we need to understand. High Court can hear appeals from the lower courts, can issue writs. This is the same power of Supreme Court. Can anyone let me know in the comment section which article of India having authority to the High Court to issue writs? So, as we know, writs having a 4 types, like mandamus, like habeas corpus, certiorari, and the 4th one and 5th one. Can anyone tell 4th, 5th and 6th what exactly is writ says? So in the violation of fundamental rights, government, High Court and Supreme Court issues writs. Make sure District Court and Subordinate Court does not have authority to issue writs. So can hear appeal from lower courts, can issue writs for restoring fundamental rights, can deal with cases within the jurisdiction of the state, exercise superintendence and control over courts below it. District Court, what mainly is working, deals with cases arising in the district, considers appeals on the decisions given by the lower courts and decides cases involving serious criminal offences. And what exactly subordinate courts is doing? Consider area of civil and criminal nature. This is what exactly the structure of our country. Supreme Court is on top, apex body, Supreme Court, High Court, District Court, and then we can note to understand is a subordinate courts. So we need to also understand that what exactly the difference of Supreme Court and High Court. In short, we need to understand here is Supreme Court, here is a High Court. Supreme Court is a principal court of justice in the country, and High Court is the highest judicial body of a state that regulates state law and order. Who is the head of the Supreme Court? Chief Justice of India, and High Court, Chief Justice of the state. Number of courts, there is only one Supreme Court in India, and High Court, there are 24 High Courts in India, 3 of which have jurisdiction in more than 1 state. Control superintendence over all law courts and tribunals of the country, and High Courts is mainly dealing with the superintendence over all courts under its jurisdiction. And who is the judge appointed by the Supreme Court? Appointed the President of India. And then High Court, President of India, after consulting the Chief Justice of India and Governor of the respective states, then they appoint the High Court judges. You have to understand the retirement age of the Supreme Court is 65 years and retirement of the High Court is only 62 years. This is a major difference as we can see it. Plea who can issue cannot plead before any court during his or her tenure or after his or her retirement. Cannot plead before any court during his or her tenure and after retirement. Cannot plead in a court before of the High Court. This is a major difference of Supreme Court and High Court of our country. And we discussed about Article 124, 127. So what exactly what this was? So here it is, as we know, here we discuss Article 124 and 147. So we go to the depth what exactly we discuss in Article 124 and 127. So here it is, as we know, Article 124, Establishment and Constitution of Supreme Court. Article 124, Clause B, Function of Commissions. 25, Salary, etc. of judges, appointment of ad hoc judges, ad hoc which means temporary judges that we need to see. Supreme Court and High Court record original jurisdiction. This is not go to the too much depth, but yes, we need to understand the article is 124 to 147 is for Supreme Court of India. And Article 143 is power of President to consult Supreme Court. 139A, transfer of certain cases and 141 law declared by Supreme Court to be binding on all courts. And now we have to understand what exactly collegium system. So collegium system in India also called judges selecting judges, because one judge select to the another judges is the system by which the judges are appointed and transferred only by the judges. The system has evolved by means of the judgment of Supreme Court and not by act of parliamentary or constitutional provision. The Supreme Court collegium which means they're not any type of college. So collegium, it means that we need to understand collegium, which means that, in short, the collegium which means that it's simple. Collegium system which means that it's simple, that like a judge's appointment to another judges. So collegium headed by the Supreme Chief Justice of India and comprises 4 other senior most judges of the Supreme Court. A High Court collegium is headed by its Chief Justice and 4 other senior most judges. This is what about his High Court collegium. Sorry for the delay. The Supreme Court collegium is headed by Chief Justice of India, comprises 4 other senior most judges. So including, there are 5 members, 1 Chief Justice of India CJI, and comprises 4 other senior most judges of the Supreme Court. And High Court collegium is headed by Chief Justice and 4 other senior most judges of that court. Names recommended for appointment of the High Court collegium reached by the government only after approval by the CJI. And Supreme Court collegium, the government can return the recommendation of reconsideration by collegium. If the collegium reiterates its recommendation, then the government is mandated to appoint the respective person. Now we have to understand the jury of judges. What is the collegium system? A firm which decides appointment and transfer of judges, comprises of Chief Justice of India and Supreme Court judges, born from 3 judges case which gave primacy to CJI call on 80s. Judiciary gets greater say than executive on 80s. So appointment and transfer. What is the criticism? As we can see, administrative burden of checking professional background data, closed door affair, lack transparency, and exclusivity, sidelines and talented junior judges advocate. President merely approves CJI choice, because that is the not role of president. So president merely only approve the Chief Justice of India choice. Some of the changes sought, CJI cannot make unilateral choices. Consulted judges' view need to be in writing. Non-compliance must make CJI choice non-binding. Transfer of judges reviewable only in case of non-compliance. So basically, in short, we need to think about it. Since independence, until now we are still talking about Beti Padhao, Beti Padhao, Beti Padhao, Beti Bachao, and we think always about like women empowerment, but it's a very regretful irony is that since independence till now we we do not have any women CJI till now. There is an Supreme Court judges, the judges, female judges in Supreme Court and High Court as well, but we do not have Chief Justice of India who is female. So this is a matter of serious concern. We need to think it. What was the need for the collegium system? And what was the, what you have to understand, like why it was why it was required? Because system was introduced for strengthening and improving the appointment process. It ensured that Chief Justice of India's opinion is not merely his or his individual opinion, but an opinion formed collectively by a body of people at the apex level of the judiciary. So preserve our democratic system by maintaining the independence of the judiciary as a part of basic structure and securing rule of law. So there is nowhere a mention in our constitution basic structure. So there is no mention of the collegium either in the original constitution of India or the successive amendments. But in short, we have to understand there are many things which are not enshrined in our constitution, but but still we are following this. While we go to the further, how the collegium system was born. So that was three judge cases. First judge case 1982, the court held that consultation does not mean concurrence and it only implies exchanges of views. Second judge's case 1993, the court reversed its earlier ruling, changed the meaning of the word consultation to occurrence. Hence, it ruled that advice tendered by CGI is binding on the president in matter of appointment of Supreme Court judge. And third judge case in 1998, the consultation process to be employed should be based on plurality of judges. Plurality of judges, which means that the consensus should be very important, which means how many judges are giving favor to it. He should consult a collegium of 4 senior most judges before making a recommendation to the president, and even if 2 judges give an adverse opinion, he should not send the recommendation to the president. This is the third judge case in 1998. Who heads the collegium system? Supreme Court Collegium, headed by Chief Justice of India and comprises 4 other senior most judges of the court, and High Court is led by Chief Justice and 4 other senior most judges. So in short, we can need to think Supreme Court Collegium having a 5% and High Court judges with 5%. Names recommended for the appointment of the High Court Collegium reaches the government only after approval by the CGI and the Supreme Court Collegium. Judges of higher judiciary are appointed only through the collegium system, and the government has a role only after names have been decided by the collegium. How does the collegium system work? For appointment Chief Justice of India, what exactly the procedure in our country? The President of India appoints CGI and other SC judges. So step 5, we need to understand the first step, that the President of India, POI, President of India appoints CGI and Supreme Court judges. The outgoing CGI recommended to the successors. In practice, it has been strictly by seniority ever since the separations controversy of 1970. Appointing other Supreme Court judges. Supreme Court judges are recommended by collegium consisting of CGI and 4 senior most judges of Supreme Court. So in short, irrespective of Supreme Court and High Court, both the collegium 1 Chief Justice and 4 other senior most judges. So there is nowhere defined who will be the senior most judges, might be in the age or we can say in the practice. The collegium recommends the candidate of law minister, who forward the prime minister, who then advise the president for the final appointment. So the role of council of minister, we can say council of minister, who is headed by prime minister of our country, is very, very crucial and vital. And president appoints chief justice in High Court in consultation with CGI, consult other Supreme Court collegium members and governor of the respective states. The candidate is selected from outside of respective state. Make sure this is nowhere mentioned in the constitution, but the candidate is selected must be from the outside of the state, because the governor and High Court Chief Justice must be from the different states. For appointment of High Court judges are also appointed by the President, who consult the HC Collegium, CJ and Chief Justice and High Court and 4 senior most High Court judges. CGI consult with Supreme Court Collegium, appointing judges of Common High Court. Judges of Common High Court appointed by the President. Make sure CGI appointed by President, CGI judges appointed by President, High Court CGI appointed by the President with the help of Governor, and judges of Common High Court are appointed by President, who consult CGI, consult with SC Collegium members and Governor of the respective states. What is the role of NGAC? So National Judicial Appointment Commission. The government through 99th Constitutional Amendment wanted to replace the Collegium with NGAC. NGSC comprises 3 judges of Supreme Court and Central Law Minister and 2 civil society experts. A person would not be recommended by NGSC if any 2 of its members did not accept such a recommendation, making the appointment process more broad-based. However, it was struck down by the Supreme Court in 2015 in the 4th judge case. So, the following provision of the appointment of judges were made, and this came to known as Collegium System of India. Appointment of Supreme Court judges. What exact Collegium System is doing? Appointment of Supreme Court judges, appointment of High Court judges, transfer of High Court judges, 4 senior most judges of the Supreme Court, 2 senior most judges of Supreme Court, 4 senior most judges of Supreme Court along with judges with 2 High Court in the concern. So this is basically the main role of Collegium System. In crux we need to understand. In crux अगर इसे समझने की कोशिश करें तो there is a 4 term that we need to understand: the appointment of High Court judge, transfer of High Court judge, 4 senior most judges of Supreme Court along with judges of the High Court in concern. Who heads the Collegium System? That's the questions arise. The Supreme Court Collegium is headed by CGI, Chief Justice of India, and comprises 4 other senior most judges of the court. A High Court Collegium is led by Chief Justice and 4 other senior most judges of that court. Name recommendation for appointment of High Court Collegium reaches the government only after approval by the CGI. For example, there are 32 members including CGI, so that recommends to the government of India, that is a person X, Y, Z, and A also, that is a person who is a senior most judges. Then government decided which one can be the senior most judges. Judges of higher judiciary are appointed only through the Collegium System, and the government has a role only after names have been decided by the Collegium. So NGAC, National Judicial Commission versus Collegium System. So what Collegium System? Collegium System is based on the 3 judges cases. What NGAC was body created by the end of 2 decades old Supreme Court Collegium System of judges appointing judges. Judges appointing judges, because a senior most judges appointed senior judges. Under NGAC, appointment of judges are made by the Chief Justice of India and 4 most senior Supreme Court judges. While NGAC, we can say, was passed by Lok Sabha on August 13, 2014, was passed by Rajya Sabha on a day later. In Collegium System has no constitutional backing, and NGAC will consist of 6 people: CGI, 2 senior most Supreme Court judges, law minister, and 2 eminent persons. Collegium NGAC is talking about Constitution of India, Article 124 to 147 is talking about the Supreme Court judges, and Constitution of India, Article 124, appointments to made by President in consultation with judges and President may deem necessary. Critics say that it is a closed door system for the lack transparency, and here if you talk about in NGAC will need support to other push a name through. They fear judicial independence being compromised, because we have independent judiciary system. Independent judiciary system. If we talk about the comparison between different countries, how the selection process work in various jurisdictions, here is India, UK, USA, Germany, and South Africa. President, since 1993, a collegium consists of CGI and other senior most judges, has made recommendation for person to be appointed as a Supreme Court and High Court judges. Person involved in making the decisions here consists of Supreme Court President, of his deputy, and one member each appointed by the JAC and England, Scotland. JAC comprised by person, members of judiciary and the bar. Senate Judicial Committee holds hearing. And here in Germany, the unique as the country has the election process to appoint judges. Here's the election process. So we can say in Germany, in terms of is so unique. Here is election is and in that elections, executive and legislature appoints judges. And South Africa recommends the list of candidates to be appointed as Supreme Court judges. All other judges are appointed by its advice. So this is need to keep in mind, because sometimes in the MCQ they can frame a question like it is a unique country has an election process to appoint judges. The answer would be Germany. Loopholes क्या है collagen system के? Lack of transparency, opaqueness, and lack of transparency and the scope for nepotism, because if the one person who is very senior most judges, they can always prefer to the own, like own caste, and we can see the person who we know having a very good relationship. So nepotism are cited often. Judges appointing judges, the attempt made to replace it with the National Judicial Appointment Commission was struck down by the court 2015 on the ground that is posed to threat to the independence of judiciary, because the NGAC appointment, that was a closed door for the entering of Supreme CGI. Some do not believe in full disclosure of reason for transfer, as it may make lawyers in the destination court cherry of the transfer judges. And way forward what it should be. In respect of appointment, there has been an acknowledgement that the zone of consideration must be expanded to avoid criticism that many appointments held from families of retired judges. If the one person is from the Sharma, they always prefer to be those one who having good relationship, and they will never choose any person who has an enmity or something different. So status of proposed new memorandum of procedure to infuse greater accountability, and it's also unclear. Even the majority of opinion admitted the need of transparency in new collegium. Resolutions are now posted online, but reasons are not given. So in short, that it should be lack of transparency and accountability that need to be built up in the process of appointment of Chief Justice of India, and we have to make sure about on this. So this is all about the session, students. I hope you enjoyed the deep dive session a lot. If you have any query, please let me know in the comment section, so that we will cover each and everything about your query. Stay tuned on Tuesday and Thursday. And Thursday, Hima ma'am will take the classes. The topic is very, very, very important, as we know that the the topic is that abortion laws in India, that we will cover by the Hima ma'am on Thursday at 3 p.m. Stay tuned. Take care. Bye bye. We'll meet tomorrow on the daily news analysis. Thank you so much for joining with us. If you have any questions, please let us know in the comment section. Please subscribe our channel and press the bell icon for more updates. Thank you so much. We'll meet you in the tomorrow session. Bye bye. Take care. Once again, thank you so much.